now respondents contend that now repeatedly saying that there's been a split and you have not merged is of no consequence because there is no one, this is no one's case. I have never argued that I have split from the political party. I'm just quoting Mullas from the transcript, how useful this transcript is, Mullas. I have never argued that I have split from the political party. We have never argued that we needed to merge with other parties. Those were defenses under the 10th schedule. Our consistent and continuous argument has been that we are within the Shivsena, represent the rival faction. Now he's accepting it. Representing the rival faction which ought to be recognized as a political party. Now, this is the cat is out of the bag. Now he is saying outside the constitution, outside the principles of constitutional law, a faction in the legislative party should be recognized as a political party. Without going to the election commission, without registering yourself, what political party? So I'm quoting only from the transcript. And has now been recognized as a political party is in question is in this matter. Then, I've said the contention that the respondents never claimed that they are a faction in the legislature, but they are a political party itself is totally misconceived. After the deletion of para 3, a faction, I've already said that. Effect of deletion is that a faction, as soon as it indulges in prohibitive conduct under para 2, would have no defense available. So they have no defense available. Respondents' justification in substance is that they are the majority faction in the legislature party, which is no justification in the eyes of law. Respondents cannot avoid the inevitable consequence of disqualification. Legality of respondents' actions is to be tested based on substance and actual effect on the impugned acts. I will not deal with it. Now, let's forget about this election commission for the moment. Now come to C3 at page 22. Erroneous conflation of legislature party and political party. I just don't understand on what basis my learned friend made this submission. The whole purpose of the 10th schedule is to talk of the legislative party and the political party as separate entities. And to prevent acts which would amount to disqualification. That's the whole purpose. The Constitution doesn't recognize that. Even the Representation of People Act doesn't recognize the legislature party. It is only in the 10th schedule because you wanted to prevent acts of disqualification. In furtherance of their smokescreen defense of being in Shivsena, the respondents have repeatedly asserted that there is no distinction between a legislative party and a political party. And again, quote from the transcript, we have consistently said so, that a legislature party is integral and originally connected and co-joined to a political party. What's the basis of this submission? And I still say, I am the original political party. So first he says, I'm a faction. Now he says, I am the original political party. Because that faction should be recognized by the governor as the original political party. Now they are presuming that this is only a rival faction. He just said that it's a faction within the legislature party and not a rival faction within the political party. Whereas your lordships have time and again said, you can't segregate the two. A legislature party is also an extension of the political party. That is how it has been right through the whole artificial distinction which has been drawn, that is that the legislature party who did it and the political party had nothing to do with it. I have never ever said that the two are different. Our argument right through has been the decision of the legislature party has the authority of the political party. Where does he get that from? Decision of the legislative party has the authority of the political party, unless he says, my faction is the political party. Thus, in substance, the respondents contend that the faction representing a majority of the legislature party is deemed to be the political party without regard to the political party which has been registered by the Election Commission under 29A. A fortiori, therefore, without referring to the original political party which has been registered with the Election Commission, the majority faction contend that they can hold themselves out as a political party and take actions within the House, dehorse the political party on whose ticket they were elected. it is submitted that a majority faction cannot claim that they are the political party registered with the Election Commission under 29A of the Representation of Peoples Act. There is nothing in law which allows such a claim to be made. Distinction between the legislature party and the political party is reflected in the provisions of the 10th schedule. Submission of Eknath Shinde Group is contrary to the clear provisions of paragraph 1 and paragraph 2 and the explanation. I have read it to your lordships, but I will not trouble your lordships with that. Then I will come to now, para 83, if the respondent submissions were correct or were to be accepted, it would create chaos within the political system with functions within the scheme of the Constitution as provided for in its various provisions, including the 10th schedule. So, now come to C4. I will leave the rest, Now, your lordships will remember all this happened much before the matter went to the Election Commission. Because there they moved on 19th July. So, all this is so per se unconstitutional. Now come to right to dissent. The respondents have claimed that the 10th schedule cannot be used to stifle dissent within the party, and definitely internal dissent does not amount to voluntarily giving up membership of the party. Well, this whole argument was raised in Kyoto in the context of Article 105 of the Constitution. Not in any other context. And was rejected. And 105 of the Constitution, I'll just quickly read it to your lordships. It says, subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. Rejected. Why? Because you are a representative of the political party and bound by the discipline of that party. You have no independent right. Unlike Parliament in England, unlike the Senate and the House, and unlike European Parliament. Respondents have claimed the 10th schedule cannot be used to stifle dissent. Then at the outset, it is respectfully submitted that the said contention is in complete violation of the decision in Kyoto, where this court specifically considered and rejected the argument that provisions of the 10th schedule violate the freedom of speech and conscience of the legislatures. It was held that people have grown distrustful of the emotive political exultations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. This court is distrustful of that, is what Kyoto says. The 10th schedule, it is urged, negates those very fundamental assumptions of parliamentary democracy, of freedom of speech, of the right of dissent and the freedom of conscience. This was urged by Mr. Jethmalani. It is urged that this unprincipled political defections may be an evil, but it will be the beginning of much greater evils of the remedies graver than the disease itself were adopted. 10th schedule, they say, seeks to throw away the baby with the bath water. So, all this I don't have to go through. And then, this went on. I will not trouble your lordships. Kindly come to para 44. Para 44 is what. But a political para, page 27, functions on the strength of shared beliefs. Its own political stability and social utility depends on such shared beliefs and concerted action of its members in furtherance of those commonly held principles. Any freedom of its members to vote as they please, independently of the political party's declared policies, will not only embarrass its public image and popularity, but also undermine public confidence in it, which in the ultimate analysis is its source of sustenance. And then, para 47, this is a quotation from Rodney Brazier. Once returned to the House of Commons, members' party expects him to be loyal. This is not entirely unfair or improper, for it is the price of the party's label which secured his election. Now, this loyalty is for a price which has secured him the chief ministership. If I can put it, differently. Then, para 49. It's the highlighted portion. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful of the emotive political exaltations that such floor crossing belong to the sacred area of freedom of conscience, or of the right to dissent, or of the intellectual freedom. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation have been the bane of the times. This is recognized by a constitution court. Above certain theoretical assumptions, which in reality have fallen into a morass of personal and political degradation. And this particular litigation is a shining example of that political degradation. We should, we think, defer to the legislature's wisdom and perception. Saying we know the reality, and that's why the 10th schedule, that's why they must not crossing the floor must not be allowed. And then Bomai, whatever may be his personal, I've already, Malaj, personal this thing, I've already read that, so I will not trouble you. Then, Malaj, now, para, respondents based on undisputed facts on record of incurred disqualification. I will not do that. I let my learned friend deal with it. Malaj actually mentioned it yesterday. Every act of theirs from the 21st onwards is an act in violation of 21A. Every act of this, which is undisputed. 21B, of course, but that's on, afterwards. Yes. Then, Malaj, now, E is the decision of the Election Commission under para 15 cannot efface the disqualification income. Malaj, whatever may be the consequence, that disqualification has already happened. Even if the Election Commission's order is right, which is ex facie wrong, but that's, we'll deal with it separately. This disqualification has happened. That cannot efface the disqualification. That's the purpose of this particular paragraph. So, Malaj, I will. Then the order dated 27/6, interdicting proceedings before the Deputy Speaker, in effect, created a hiatus in the operation of the 10th schedule. I've already, Malaj, dealt with that. So I won't trouble your lordships with that. And then the list of dates. Then the only thing I have to now, Malaj, is to go back on my written submissions. On my written submissions. Original written submissions. Yes. Now, Malaj, I want your lordships to look at the chapter relating to whip.
In your rejoinder?
No, Malaj, my original submissions,
Yes.
chapter relating to whip, that is PDF page 70 in my written submissions.
70.
On mine.
70.
70. So just have a look at it.
Chapter 7.
Yes.
Chapter 7 on whips. And Malaj, they did not address your lordships on this at all. The only thing they gave was that document which I showed to your lordships yesterday.
Only one thing which they have said about
Yes.
whip is
Yes.
that they have referred to the disqualification rules.
Yes. Oh, yes, I have to deal with
And
that.
perhaps you may want to.
I'm sorry, I should. In my,
Related to 3-1.
I'm going to show that immediately, Malaj. That's my mistake. I should have, in my desire to finish quickly, Malaj. Kindly go to those disqualification rules. There is compilation, Malaj.
Rule you will have.
Yes, statute compilation. F. This is PDF, Malaj, page 6. Thank you, Malaj, for reminding me. I should have dealt with it.
I have some doubts, so
Yeah.
Yes.
Malaj, definition of leader. Your ladyship has it, my lord has it?
Yes, we have it.
Leader in relation to a legislature party means a member of the party.
What is he referring to?
He's reading Maharashtra letters to say.
तो ठीक है, कोई बात नहीं।
First bookmark,
Page
page 2,
हाँ, एक बजे कर लो।
rather 4,
516.
definition.
तुमको भी टाइम मिल
Definition.
Oh, okay.
हाँ।
Yes. Thanks.
So PDF 6.
Yes.
6.
Say leader, lordship has that now?
Definition.
Leader in relation to a legislature party means a member of the party member of the party chosen by it as its leader. Chosen by the party as its leader. Member of the party chosen by it as its leader. Complete misreading of this definition, Maharaj. And includes any other member of the party authorized by the party to act in the absence of the leader. Authorized by the party. Consistent, Maharaj, with all my contentions. This is not in the domain of the legislature party. The party chooses the leader, the party chooses the whip. So this argument that I had thrown you out, Sunil Prabhu I had thrown you out, therefore I need not have recognized Sunil Prabhu at all on the 3rd. Because I had appointed Gogavle. Amanas, yesterday, an argument was made, how could the whip act outside the house?